My name is Sean Suhar. I'm an attorney with the firm of Nagle and Zaller. Our firm practices in the area of community association law. We do both collections. We have a busy collections practice, as well as non-collections issues. And from what I understand, here tonight for Collections 101, the impacts of COVID. So I've come prepared to kind of give a general overview of Collections 101, just kind of start from the beginning. When an account is, what I understand is everyone tonight is either serving on a board of directors in some way related to the governance of a community association or a condo or a homeowners association. Just kind of give an overview of the collections process. And everybody knows that assessments are mandatory, but pursuant to your governing documents. And so when an owner fails to pay, an account is typically turned over by management to the law firm for collections when it is at least 60 days past due. That's kind of the bare minimum. You know, we won't collect it unless it's at least 60 days past due. And I believe the same, you know, generally my comments are related to my office generally, but I think
60 days is the earliest that you should think about referring the account. Sometimes the longer period is justified based upon the amount and frequency of the assessment.
So the attorney will, once an account is referred for collections, the attorney will do a thorough review of the account, check the statute of limitations, pull the deed, pull contact information from the Maryland SDAT, and review the pertinent sections of the governing documents and check bankruptcy and foreclosure status. Building a file for the account, the debtor's account. And so the first correspondence that's sent by our firm is a notice of intention to create a lien, or what we call a suit lien warning letter. That letter is crafted to comply with state and federal laws. We attempt to get, and let me just say at this point, throughout the entire collections process, we're always attempting to get payment in full or establish acceptable, reasonable payment arrangements with the debtor throughout the collections process. Most of the time, the debtor either pays or establishes payment arrangements to avoid having a lien recorded against their property, which is the next step. And so a debtor can establish payment arrangements for up to 120 days, the date that they receive the NOI, or we kind of have to start the process over again by sending another notice. But if the delinquent owner fails to pay after sending the notice of intent to create a lien, then we record a lien against the property among the land records, county land records, and then send a notice of lien recordation to the delinquent owner, and with an intent to file district court lawsuit. And so after the time expires, after we give them, 15 days or something like that, if the delinquent owner still fails to pay, then we proceed with filing of a lawsuit, typically past due, and there may be other factors there. But generally speaking, if we proceed with the lawsuit, we're typically filing upon board approval, typically filing in the district court. Once the delinquent owner is served with a summons, then we try and settle the account by getting payment arrangements pursuant to a settlement agreement. But if not, we'll proceed to trial and obtain a judgment. Now, once we obtain the judgment and the time passes where we can then collect upon that judgment, then we can proceed with what's known as a garnishment action, a garnishment on wages or income such as including any source of income from the person's job, rental income, or other sources of income. Or we can do a garnishment on the debtor's bank account. But if we don't have information about where the debtors come or their bank account information, then we can file what's known as an oral exam. This is like a discovery process for collections on judgments. It's a court-ordered process which allows us to ask questions and collect the information about income and assets and other information about the debtor in court. If the debtor does not appear in court for the oral exam, the judge can show cause hearings, and if they still fail to appear, order the defendant to be arrested. But due to a new statute that's supposed to go into effect coming here in October of this year, That process will no longer be available in small claims matters where the principal balance is under $5,000, inclusive of interest, late fees, costs, and attorney's fees.
Sean, I'm not sure if you're aware, but on May 27th, Governor Hogan vetoed that law. And I'm not aware that it's been overridden yet, but that happened on May 27th. And so we're waiting right now to determine whether or not the legislature is going to override Governor Hogan's veto. But I did see that law as well. And I can tell you that I was frustrated by it, as I'm sure you are too.
Absolutely. Thank you. If the normal processes, which I outlined very briefly, are not working, then I usually have a conversation with the board of directors about taking more extreme actions, such as writ of execution, which is commonly referred to as a sheriff's sale, or a foreclosure action. I can review those differences later on in the discussion, differences between the two types of what I call more extreme action. Both would lead to the same result, which is where the delinquent owner would lose title to their property unless they pay. I have a collections flow chart. I didn't prepare to try and share it with me, share it with everybody on the screen or what have you, but I can send a copy of this collections flow chart for anyone who wants a copy of it, which is reflective of what the process that I just outlined. But I strongly recommend that every board of directors adopt what's known as a collections policy, which we provide as a free service for our clients. This serves as an administrative instruction from the board of directors to management and the attorney on how and when accounts will be turned over to the attorney for collections and how payments are to be applied when an account is in collection. We also provide a monthly collection status report for our clients so that the board of directors is aware of the current status, current balance of each account, current collection efforts that we're taking. It's important to read the status, board members to read the status report in detail in case we need certain information about a debtor, times that they're home if we're trying to effect service of summons, or if we need the name of a tenant, we're trying to do a garnishment of rental income, or if we need a decision from the board of directors agreement. A couple other items before I kind of finish up with an overview is that there are statute of limitations that we need to be aware of. For a lien, it's 2 years. We can go back, plus we can accelerate the debt through the end of the current fiscal year. And for a lawsuit, statute of limitations, 3 years, except when the governing documents, in cases where they're under seal, then statute of limitations would be increased to 12 years. There was a Court of Appeals opinion in Columbia Association versus Poteet a number of years ago, extension of the statute of limitations. And lastly, suspension of parking privileges and other common area privileges. There was a major case, Elverton Town Condominium. The Court of Appeals in 2017, the highest court in the state, Court of Appeals, issued its binding opinion on June 23rd, 2017, which held that if a condominium in Maryland wants to revoke parking privileges, such as parking or pool privileges due to non-payment of assessments, then the authority to do so must be in the declaration itself. Amending the declaration, and if it's not in the declaration, then condominium, if that authority is not in the declaration, then the condominium would not be able to suspend parking privileges due to non-payment of assessments. To amend the declaration, it would require at least 80% approval of the Council of Unit Owners pursuant to Section 11-103 of the Maryland Condominium Act. I ran through a lot of information very quickly, but I wanted to kind of give an overview of Collections 101 as I see it.
We have a question.
Oh, go ahead.
We frequently have delinquent accounts because of foreclosure or death of owner. Can they please review what steps are taken in this instance?
If an owner dies, then their property becomes property of their estate. And oftentimes what happens to that property is dependent directly upon whether or not the estate is solvent. If you have a person who dies and they're insolvent, oftentimes the heirs or the family of that person who died abandon any interest in the property and essentially wait for the bank to take it back at a foreclosure. Oftentimes, when you have a situation like that, and it all is case specific and dependent upon the facts of the individual delinquent account. And the differences usually depend upon the amount and the frequency of the assessment, the size of the debt, whether it's a condominium or a homeowners association. If you have a property that's owned by an estate, what you need to do is evaluate the equity position in the property. If the property has very little equity in it, the likelihood is that the bank has a mortgage in it, will be ultimately taking that property back. If the estate has a good equity position, it's likely that the personal representative of the estate will seek to probate the title to that property and either transition it to an heir or sell it as an asset of the estate. It's very important in those cases that you file an estate claim with the estate so that they're aware of the claim. You can seek to establish liens against estate-owned properties just like you can any other property. And if you have liens in existence at the time that the person passes away, those liens are liens against the estate as well. So if you have a situation where a property's upside down, it makes it very difficult for you to take action because one, you're always from at least second lien position. And you oftentimes, if an estate has not been opened, if your plan is to try and compel a sale, a foreclosure or a sheriff sale on the property, you'd have to petition the court to open an estate. You'd also then have to pay to have an attorney appointed to represent the estate for the purposes of service of process. And then you'd have to go through all of the other steps that are associated with either a sheriff sale or a foreclosure action. And depending upon the debt and the circumstances, that may not always be very attractive. Ordinarily, unless there is some great equity position in the property, I recommend to my clients that they wait to see how the bank is going to treat the property and to take it back. The extreme differences are if you have an association that has a very large assessment, say it's like $600 or $700 a month, and the debt accrues rapidly and aggressively, you're going to want to be more aggressive than you would, say, if you were in a homeowners association with a $500 annual assessment. Oftentimes, a foreclosure action or a sheriff sale can cost well into the thousands and as much as $5,000 or more to prosecute. But if you have an HOA with a $500 annual assessment, it would take 10 years of delinquent assessments to equal the cost of that action. If you have, and I will tell you, this in an estate, it's unlikely that an estate would ever file bankruptcy. But as Sean was talking about those actions earlier, there is always a chance that the debtor in a sheriff sale or a foreclosure sale could file bankruptcy to stop the case. So there are always risks that you need to be aware of when you're deciding how to proceed in any individual case. I hope that that kind of answered the question about what to do about an estate. But if there's a follow-up question, I'll be glad to hear it.
Yes. What about the maintenance of it? Say you have an overgrown front yard where it's taken over the whole front of the house. You can't even get to the front door. What is the HOA's recourse in remedying that?
When I'm presented with that issue for my clients, the first thing I do is review the governing documents and determine what enforcement actions you're able to take. And oftentimes documents will have what's called a self-help provision in the documents, that if you have a property that has become a blight on the community and has some exterior maintenance issues that can be relatively easily remedied, oftentimes I would advise my client that you can put the estate, or if it's just an owner, on notice of your intent to exercise self-help and to grant them an opportunity to do the work themselves. And if they fail to do it, then take that action. I never recommend self-help in anything other than exterior maintenance and nothing that requires you to access the structure. If you are presented with a property that is in an eyesore or causing issues, and it involves something like replacing a roof or replacing windows, I ordinarily recommend my clients seek a court order to compel the owner to clean it up. If the owner fails to clean it up after a court orders them to do so, then they can be held in contempt of court and fined by the court. So there are a lot of different nuances to self-help and exterior maintenance, but it largely depends upon what it is. For example, if somebody's got a pile of trash in your front yard and they just refuse to move it, and the association has access to a service that will come and remove it, put the owner on notice that you intend to do that and bill it back to them. If you happen to take that action and incur an expense, oftentimes you're able to recover that expense from the owner through the collections process.
Yeah, and to kind of build upon what Mike was talking about earlier about foreclosure or sheriff's sale, what have you, what I've advised my clients, and this is especially has to do with accounts that are perpetually delinquent for years and years and years, and it just seems like on some cases where the collection efforts are just not normal collection efforts, lien and lawsuit, post-judgment collection actions such as garnishment, they're just not working. And so what we'll do in those cases is sometimes I'll advise a client, first of all, what we'll do is a foreclosure feasibility study that will give the client an idea of what kind of equity there is in property, and we'll analyze and determine whether it would be feasible, whether there's enough equity to justify either doing a sheriff's sale or foreclosure. But in some cases, when the balance is like for a homeowners association where $1,000 a year annual assessment, and all of a sudden the account is now $8,000, $9,000, $10,000 delinquent, and it seems like the normal processes are not working, I've advised the board to consider the sheriff's sale as an option in order to stop the bleeding, if you will, because I've seen accounts where board will hold off saying, no, it's not justifiable. It doesn't make sense at this point. And then all of a sudden the account is now double that amount. It may be, $16,000, $17,000. And then all of a sudden the board then decides to proceed with a sheriff's sale. They're kind of like shooting themselves in the foot, if you will, standing to lose potentially a lot more in assessments, unpaid assessments, where we could have addressed that issue before. So really depends upon the facts, the amount of debt, and a lot of various factors in there.
Right. And the feasibility study that Sean's talking about is something that we do as well. And the most important aspect of that study is the equity position in the property, because if the equity position is not sufficient to attract a third-party bidder, and the association itself is not in a position to or willing to purchase the unit itself, holding a sheriff's sale without the willingness to buy back the unit could lead you to have a no sale result, where no bidders show up and no one is there to acquire the property, basically because people who bid at these forced sales are investors looking for a profit. And because they're not able to assess the value of the unit by inspecting the interior and knowing exactly what the condition of the property is, they have to anticipate that they may need to remodel, redo a kitchen or bathrooms or flooring and painting, and that there's substantial expense in turning that property over. And because they're buying it sight unseen, most investors will not bid on a property that doesn't have at least a 70% loan to value ratio. So part of that feasibility study, a very important part of that feasibility study is understanding what properties are eligible for a sale based upon their ability to attract a bidder.
Okay, I have another question. It says, we had a homeowner that was recently delinquent for 2 years that filed and was approved for bankruptcy. Their debt was cleared with no payment to the HOA. The same homeowner is now delinquent again this year. What can the HOA do?
Well, in a case where an owner has been discharged in bankruptcy, if it was a Chapter 7 bankruptcy discharge and the association had a lien in place at the time of the discharge, while the debtor is discharged personally from the obligation to pay that debt, the lien may still survive that. And if there's a subsequent sale or refinance, that lien may be revived in order to recover some of that debt. However, a debtor is not going to be able to get a discharge more than once every 6 years. And if a person becomes delinquent again after already having been discharged in bankruptcy, you proceed against them as you would any other debtor. They're not going to be discharged a second time. Now, a person can file more than one Chapter 13 case, but if they've already received a discharge in a previous case, all of their unsecured debts would still have to be treated as fully secured.
Okay, I have one more. Would you say that the court has a bias against the HOA? How many times?
Absolutely.
How many times does the court grant a full judgment against the delinquent person?
Well, here's what I'll tell you in my experience, and Sean can probably dovetail off of this. Oftentimes courts, judges, who are people just like you and me, have a perception that when an HOA is suing an owner, it's sort of a David versus Goliath kind of a scenario where the association has more power than the individual owner. And there often is a very consumer-oriented bent to the district court bench, where they, for lack of better words, take pity on the delinquent owner. And there are some judges that are very thoughtful in the process, and there are some that are less than thoughtful in the process. I will tell you that we have a pretty good time in the district court having our attorney's fees and costs awarded in the cases. But every now and again, you will run into a judge who is a strict 15%er, as we call them. There is a case out there, and I'm sure Sean's familiar with it. It's called the Monmouth Meadows case, that says that it's improper for a court to simply award 15% of the judgment principal as a blanket rule. What the courts are supposed to do is analyze what went into the case, what actions were taken, the reasonableness of it, the amount of the debt and controversy, and all of that, and create a fashion a ruling that determines what a reasonable attorney's fee is. 0 is never a reasonable attorney's fee, according to the Court of Appeals for the state of Maryland. But there are frequently judges in the district court who will award 0 attorney's fees. We adopt a pretty cautious approach with our clients, especially ones that have low annual assessments. What we say is you cannot race into court because somebody owes you $500. If you do, you're going to spend more than you recover. So what we do is we typically will secure a lien in the property, notify the owner that we've done that, and if they fail to pay, we will wait for a subsequent year to come due so that we can consolidate in a single suit that debt. And if you get in front of a judge on a case like that, you can demonstrate reasonableness by showing how prudent and cautious you were, and how you waited a reasonable amount of time, and but for the continued delinquency, you wouldn't have had to bring this suit at all. The thing that you have to be careful about is running up against the statute of limitations. As Sean said earlier, in the vast majority of the cases, the statute of limitations is 3 years. So typically, in the very low assessment cases, we would wait until that 3rd year came due, which is practically 2 years and 1 day, and file the suit. If it's a high assessment case, like in a condominium case where you have assessments for $200 or more a month, we would file suit in the 1st year, just because you cannot wait around, because this debt will compound. But it all depends upon the circumstances of the association that is owed the money. And a competent attorney would evaluate all of the factors associated with the risk and expense of proceeding in any given manner, and let you know what they are. Sean, do you have anything to add to that?
Good answer. I agree. There is some biasness there. So I don't see any more questions in the chat at this point. So I thought that maybe we can kind of shift into the impacts of COVID and so forth, because I think that was part of the discussion, if that's okay.
And we can always jump back to questions as they come up. But yeah, I think that there's a whole lot going on with the courts with relations to COVID. I'm sure everyone has COVID fatigue at this point in their life. And I know I do for sure, having had it twice myself. And I will tell you that it's presented a lot of challenges for attorneys doing this type of work. The very first challenge was in March of 2020, the courts closed to our types of cases for a period of almost 9 months. They were accepting filings, but doing nothing with them. They would receive a case filing, and sometimes early on in the process, it could be a year before a summons was issued on that case. And that presented a lot of challenges because we're waiting for the court processes to work through. I'm sure, Sean, you and I have both had frustrated clients by this, and it's frustrated us as well because we're eager to get to work on these cases, but we're not able to because the court and its processes have slowed significantly. Another problem that has been caused by this, and I don't know if you've seen this in your practice, Sean, but here lately, we filed cases, and then by the time they come around for affidavit judgment consideration after having been served, some courts are now saying, well, the non-military affidavit that you filed with your case is no longer valid. We're denying judgment and you have to refile. Have you had that happen at all?
I'm sorry, what was that? You froze on me.
Where the court is declaring the non-military affidavit too old to enter judgment.
Yes.
So it's been my experience that oftentimes district court clerks and some district court judges look for any reason to kick a case back. And so you have to try and anticipate that and work on them. But generally,
absolutely,
many of the courts are starting to get caught up, but there is still a significant backlog. There are some counties and jurisdictions are worse than others. In my estimation, the one with the biggest problems is Prince George's County, simply because they have not embraced and enacted the electronic case filing system yet. Prince George's County and Baltimore City are the only two jurisdictions in the state of Maryland that have not yet implemented the electronic case filing system. So we still have to do manual paper filings with the court, and that causes delays and backlogs. And but my understanding is that the administrative judges in Prince George's County have indicated that their goal is to implement the electronic case filing system by the end of this year. We'll see if that happens. I'm hopeful that it will.
Right. There's also been some good comments, Mike, on that, because there, has been a serious backlog, especially in Prince George's County. We've also seen a backlog in Baltimore City as well. But there were no less than 10 administrative orders issued by the Maryland Court of Appeals regarding the operation of courts during the pandemic. And there was a moratorium for about 20 months, almost 2 years, on foreclosure actions. So sheriff sales were also impacted, even though there wasn't a moratorium on sheriff sales, but they were delayed with everything else in the courts. So I don't have any other comments in regards to impacts upon COVID, other than I do want to actually discuss, and some people may or may not be familiar with the Maryland Homeowners Association Assistance Fund. It's called HAF. Yeah, and so this could be beneficial to people who are homeowners, unit owners, and condominiums dealing with financial hardship as a result of the pandemic. And so there are income limitations, if you will. It's based on the average or the median income. But this is something that that you all may want to mention to homeowners that's available for assistance. From what I understand is that you could get a grant for that would help with payment of a homeowners association or condominium assessment, a maximum assistance of $20,000 pursuant to the website now. I thought it was 10, but it says on the website that I checked today is $20,000. So I don't know if you have any more comments, Mike, that you want to make on that one.
one of the things, I'm sure you're doing this as well, Sean, but one of the things that we do in my practice is that whenever a debtor calls and they have a significant arrearage, we mention the HAF program to them and encourage them to apply for it. Because if they truly are having financial distress and have an inability to pay this, that is a great resource for them to apply. That there's a similar program that also deals with rental and rent reimbursement and mortgage arrearages. But obviously, our primary goal is to get their condominium and HOA fees current. So we provide debtors who are in contact with us contact information for the Maryland HAP program. And I think that it might be helpful for any of the boards that are on this call, that if you have a community newsletter, it wouldn't, or a community mailing going out, it wouldn't hurt to include a little blurb in there mentioning the Maryland HAF program to owners in the community in case any of them are behind on their HOA assessments, or if there are some in your community that are current on their HOA assessments but behind on their mortgage. That program will help them as well. So that is a very fine program. We've been able to help a number of people clear up their accounts through that program. And if it gets the association paid and helps an owner in your community at the same time, I consider that a win-win.
Right.
They actually emailed me today, and I have to send them tomorrow 6 association W-9s for some of the homeowners.
Right.
Yeah, they require proof of the debt and W-9 information for any association that's going to be receiving funds through the program. It's part of the regulations of the program, but it's not a huge hurdle for us to provide that information. And if it means that our clients are going to recover the money that's owed to them, all the better.
It looked like somebody had asked for us to repeat the name of the program, and then I saw a response. It's actually Homeowners Assistance Fund. It's HAF, HAF, Homeowner Assistance Fund. And if you Google it, you can Google Maryland HAF program, or
it'll come right up.
Come right up, yes. Okay. So, and then there's another question I see here on the chat. Joanna, if I may, or do you want to
go right ahead?
Yeah,
that's fine.
My HOA wants to update our bylaws. Are you also familiar with current practices that we can consider? Our firm has done a number of amendments. We either do a spot amendment or a comprehensive amendment and complete restatement of the bylaws, whether it's a homeowners association or a condominium. But what I would recommend is if you contact our office, we'd be happy to review the governing documents with the board of directors and give an opinion on, on those spot issues. And if there are a number of issues that need to be addressed, then maybe a spot amendment, like, on 1 or 2 issues would not be appropriate. Then at that point, we may recommend doing a comprehensive amendment, a complete amendment, a declaration if we're talking about homeowners association. We have a fixed price for that project, so it's a really good deal. We would update your governing documents completely and address all the laws that have been changed and so forth over the years. And I wouldn't say age of your documents is a particular factor, but really has to do with the number of tools and remedies that you want available to the board of directors for enforcement of your recorded covenants, and just updating the documents with the law.
Yep. I would to dovetail off of what Sean was just saying, that spot amendments, or as I like to call them, standalone amendments, are oftentimes easier to pass. And if you have a more controversial amendment, that might be the way to do it so that you're not spending a significant amount of time. One of the difficulties, and I'm sure Sean will agree with this, is that if you are to do a complete rewrite of your governing documents, you still need the approval of the owners in order to implement them. And oftentimes, if you present a book, and it literally would be a book, sometimes in excess of 50 to 100 pages, to the owners to review and approve, oftentimes they don't. And they will look the other way or say, well, I haven't had any problems with the association the way it exists, and these aren't that important to me. You may end up spending a significant amount of money and still not getting those changes made. It all depends on your community. So it's all, in what I typically ask my clients when they're considering bylaw amendments or declaration amendments is think about the history of your community. What areas in the past, through your experience, have you found that your community governing documents are lacking? Is there a particular provision that let you down in the past? And if so, we can do a targeted amendment for that to fix that problem. And it's very inexpensive because it only takes an hour or two of attorney's time to craft an amendment to meet that one thing. Whereas a complete rewrite of your governing documents could cost well into the high thousands, 5,000 or more. And there's no guarantee that after expending that money and undertaking that effort, that you'll be able to get owners to agree to implement them. So, while preparing a document may be, relatively desirable, passing it can be relatively difficult. So you have to think about your community, think about what level of participation you have in the community, whether or not, I take for instance, here's one example. If you are a community and you have 40% of your community is investment property, which is really high, and it creates problems for you. It might be extremely difficult to convince any of those owners who are already renting their unit to place a rental cap on. That's just one example. Another example is if you don't presently have fining authority in an HOA, sometimes people will recoil at the idea of granting fining authority to the board. You can always propose it. And one of the best ways to find out whether or not what the appetite of a community is towards such an amendment process is to take a survey of the community and see if you get any response. If you don't get much of a response, it may require some serious elbow grease on the part of the board and some volunteers for the community to go door to door to solicit proxies approving this amendment process. So those are all the things that you have to think about before you decide to invest the money in a major rewrite of your documents. And if you determine that a major rewrite is not the best fit, then a spot amendment may very well be the trick because it can be attempted a lot less expensively. And I agree with Sean, the age of your documents isn't necessarily the issue. It's what's in them and whether or not they are sufficient. Something that you do not need to do is if a law is changed to invalidate a provision in your governing documents, you don't need to amend them to remove it. The law is just going to prevail. That's all there is to it. But if there are things that the law says are now the case, you most likely will not need to amend your documents because the law already provides for it. I hope that wasn't too long-winded.
So there's a question about Maryland tree law.
Ah.
Baltimore County. Best law to give owners regards common and neighbors' trees.
Yeah, well, ordinarily tree law in Maryland when it comes to trees on private property is that if the trunk of the tree is on your property, the trunk of the tree is your property. However, if the branches of those trees hang over an adjacent property line, the portions of those trees hanging over the adjacent property line are actually the property of that owner, and they may trim them back. Something that you need to be careful of is if you have dead or dying trees on common areas, because if one of them should fall and damage property or injure a person, the association could be liable. I'm aware of an association in Baltimore County that had a dead tree on its common area that fell over onto a road and struck a passing vehicle, killing the driver. And that association's liability policy was pushed to the limits. And so it's always good to survey your community for tree issues. And I don't know whether or not the person who asked the question about tree law had a specific instance that they'd like to tell us about, but I'd be glad to share my opinion with you on it.
Andrea?
Right now, it's been basic, being that I am at some new properties, because this is my first month dealing with some of these communities, but it's been a lot of tree issues in regards to the branches are hanging over on my property, and I know it to be as the tree law. I believe it's the apple pickers or somebody's pickers law. As long as the branches are falling over on your property, the homeowners have every right to cut them back, especially if they're saying the branches are hitting my roof and everything else. You tell them that you have every right to cut the tree branches back, but they don't want to hear that. They want to hear, okay, when the association is going to take care of it. And, you know, they want you to act quickly, but when you tell them, okay, it can be at your cost, you know, when is the association going to do it? And so lately, and again, I'm just a month in, they're like, oh, tell me the law, you know, where does it say that at? And I know I found it on the Baltimore County website. And also I see verbiage from different law documents for the state of Maryland that state the same thing that I'm saying. But I understand if it's on common area, but again, telling the homeowner that, you know, it's okay for you to cut it back. It's at your cost if it's that much of an emergency to you. And just
Right.
trying.
If a tree is not in danger of falling or visibly unhealthy, then it is up to the owner of the property that the portion of the tree is on to do with it as they please. Now, if it's a common area tree and it's hanging over someone's roof, then the association may want to get involved just because, you know, they don't want to cause damage to someone's property. But if it's just, well, I don't like the tree and this portion of this limb is hanging over my property, it's causing shade in an area where I don't want shade, it's up to the board. I mean, they could decide to trim the tree back, but they can't be compelled to do it under Maryland law. And one of the things that I might suggest to you is when someone says, show me the law, just say, you know, well, unfortunately, I can't provide you legal advice, and you're going to need to get legal advice from your own attorney.
Hey, to carry forward
Gotcha,
with that,
thank you.
one other question. So when trees are in a forest restoration area that is actually deemed the association's property, and someone who does not live on the association complains about a tree that's in that forest restoration area, then it is up to the association themselves to make sure that that tree that's in the forest restoration area is taken down, or would that be the county's responsibility?
It really depends, because if you're talking about a forest conservation area, I mean, you need to be very careful about what you can and cannot do in that forest conservation area. So there are typically rules that are set up by either the state or the county that when at the time of development, when the developer agreed to the forest conservation area, then sometimes you're not allowed to do anything with the tree if it falls, for instance, you know, and it's just the county just would want it to just feed the forest floor or what have you.
Is it threatening someone's property?
Well, if
it's threatening.
Yeah, if it's if it's a dead tree and it looks like it's at risk of falling, you're going to want to have it taken down, especially if there's adjacent property or people that might be injured by it. Absolutely. And if that dead tree happens to be in a forest conservation area, you certainly would want to clear it with the county before you take any action to remove it. And I always recommend that whenever a community client of mine removes a tree, that they document the condition of the tree before they remove it, in case there's a question as to whether or not it was dead. Most tree services that you frequently, I don't imagine any board members are getting out with a chainsaw, and I certainly wouldn't want them to. But if most of the tree services out there are well aware of the legal requirements for permitting of tree removals in the jurisdictions where they work, and if you're relying on a tree care professional, you should ask them, are you aware of any permitting requirements for this tree's removal before they do it?
Okay, thanks.
And I just thought I'd add that this discussion about tree liability and so forth extends to what's below the ground as well. I've handled a number of tree liability issues, and some of them have involved the roots, and questions arose as to what could be done, what must the owner do, or what have you, in regards to roots that invade another person's property. And so the same general rule of thumb applies where the owner is not of that tree is not responsible for cutting back their roots if they invade another property, but that the adjacent property owner can trim those roots back. And so I thought I'd mention that as well.
I agree.
Thank you.
There's a question on here is, what is considered a quorum for a homeowners meeting? If the bylaws say you need 60% approval to amend, do we need 60% to attend a meeting to get the change done?
Well, the quorum requirement is always established by the documents, and oftentimes the level of approval required is well beyond a quorum in many cases. Sometimes in an HOA, approval of a bylaw amendment can be as small as a majority of a quorum. So if you have a quorum in attendance and you can amend your bylaws with a majority vote. But if you're talking about a condominium, your quorum requirement is going to be way less than 60%, but you still must have 60% vote to approve an amendment to it. Not all of those people have to be in person. They can respond by proxy. So you may have a meeting with less than 60% of the community there in person, but nonetheless have enough paper proxies in order to achieve that threshold. But if you attempt an amendment and you're not able to achieve that level of approval, then the amendment process fails.
And that's one of those issues that Mike was referring to, where there's a change in the law that may not necessarily be in your governing documents, where what I'm talking about is that the law was changed a few years back, 2017 or 16 or 17, which reduced the number of, or actually established the percentage at 60%. At least 60% is what's needed to amend your declaration or bylaws for a homeowners association or your bylaws for a condominium. No matter if your current governing documents require 75% or 90%, and it's 60%, at least 60% approval would be required by vote of the membership. You don't have to have like a written document. And it's only 60% of those who are less than 90 days delinquent in the payment of assessments. So if there are owners who are more than 90 days delinquent in the payment of assessments, they wouldn't be counted in that percentage requirement. Any questions?
I would add that sometimes there are differing voting disqualification provisions in some associations. Some of them may require that a lien statement be recorded in order to invalidate someone's right to vote. And I've seen others that have the invalidation be lower than 90 days, some that have 60-day thresholds in some homeowners associations. So it's always important to review the governing documents to determine what would make a person eligible or ineligible to vote. Joanne, we have another question.
Actually, it's just someone's asking if we can limit questions to collections.
Or do we have any collection questions?
So no, my next question on here would be workers' comp coverage. So,
Well, workers' comp coverage is required for any person who employs another person as an employee. Workers' compensation coverage applies to both of our law firms. All of our employees are covered by workers' compensation, but workers' compensation is not something that you extend to a contractor. Contractors typically are responsible for their own workers' compensation and for that of their employees. If there's a specific issue related to workers' compensation, Sean and I will be glad to hear it.
it says
Homeowner
for
volunteering.
volunteer.
A volunteer is not an employee. That would be the simple
What
answer.
I would recommend is if you want to thank you. I don't know, Mike, I'm sorry if I interrupted you.
Go right ahead, Sean. Go right ahead.
If you have a volunteer, which is a great thing when it comes to a community association, I'd recommend that you enter into a quick agreement with that person that would clarify that they would be operating as such and not an employee of the community association. We've assisted clients with doing that, and it would include a waiver of liability or indemnification, that type of thing, and so I recommend doing that because it helps the volunteer understand and the association understand that there is no workers' compensation being provided to that person because they're operating kind of like an independent contractor, if you will, or a volunteer.
Right, and those agreements don't have to be lengthy. They can be a single page, as long as they have the right language. And one of the things that it should say in there is that the person acknowledges that they're acting as a volunteer and assume any risk of injury associated with that volunteer activity.
Right, right.
So are there collection related questions that anyone has?
I have another topic.
Go right ahead, Sean.
So I wanted to kind of review some new laws that have been adopted by the Maryland legislature in regards to reserve studies. Now, this can impact the whole collections idea, if you will, because it impacts your budgets. Ever since the Surfside condominium collapsed in Florida, I think probably most states, if not every state in the United States, has been grappling with this problem, this issue that was presented in that case. It was just a horrific incident that happened that I think everybody in the country knows about. But when I say, and the state of Maryland has been very active in this area. They've adopted twice. First, they adopted a statute that affected Prince George's County communities, including condominiums and homeowners associations. But then the following year, the legislature added Montgomery County to this requirement. What the requirement is now, they've adopted another statute this year that will go into effect in October that will be applied to community associations across the state. And what that is basically that the community association, such as a condominium or homeowners association, is now required to conduct a reserve study at least every 5 years. And the recommendations that are made by a third-party contractor that's hired to do the reserve study, the recommendations shall be the reserve amount in your budget. And so in those cases, that can affect your budget significantly. It's already affected a couple of my clients that I'm aware of in a big way, where I've had a homeowners association that had to raise over $1 million And a condominium is dealing with having to raise over $5.5 million within the next 3 years. That's monumental, especially when there are only 143 units there. But I just wanted to kind of start this discussion, if you will, on reserve studies and how they can affect your budgets, and how they will affect your budgets, because now it's required by law that the reserve study be done at least every 5 years, and that the that basically that reserve recommended amount be part of your budget. And there are also now mechanisms to assist, to make it easier for the board of directors to raise the funds necessary to fund those reserve requirements. I kind of gave a really brief overview of the new law, or laws, I should say.
One of the things that this will do is that if you have a mandated reserve contribution requirement, it eliminates the need for unit owner approval of that in your budget. If it were to increase your budget substantially, sometimes there are hurdles that you have to pass ordinarily if you wanted to amend your budget. But if this is a mandated expense, which it is, it makes it easier to adopt the budget. Doesn't make it any easier to pay, but it makes it easier to adopt that budget.
And when we talk about reserve items that would go into a reserve study, or those long-term projects, such as like a roof replacement project, you're not replacing a roof every couple of years. A roof has a lifespan of 20, 25 years or what have you. And so roadways, siding work, or what have you, these are things that the association thinking about long-term, and not having to impose large amounts all at once to accomplish a $5.5 million reserve contribution and repairs all at once in order to, keep the condominium from either collapsing or causing serious injuries or death to people in the condominium building. So this is something that's very important, and something that boards of directors should be considering.
The reserve amount shall be portion of the new reserve study law. You were stepped on by a caller. So it says, please repeat, the reserve amount shall be portion of the new reserve study law.
Well, for those of you who don't know, what a reserve study is when a qualified engineer or reserve study specialist will examine the infrastructure components of your community for which the community is responsible for the maintenance, repair, and replacement. And what they do is they assess the useful life of all of the components of your community, and then using standards of the industry, project what the replacement cost of those items will eventually be. And then what they do is they amortize over time how much money you will need to put away each year to meet those anticipated expenses. And so whatever each year's anticipated reserve need is the amount that you need to budget for it. And that reserve study itself will give you the projections, will give you all of the data that went into it, and let you know, in order to be adequately reserved under the law, you need to contribute this amount each year. And then the law does require that the reserve studies be repeated every 5 years. So if there's been something that had extraordinary wear and tear during that 5 years, it might be reassessed at a higher contribution level. If something has weathered exceedingly well, it might be reassessed as having more useful life than it did before. But every 5 years that you have these reserve studies done, you will get a new reserve contribution allocation.
So it says, if your reserve fund has been depleted, how do you raise funds to replenish it? We already have a small amount going towards it, but it's not enough.
You're going to have to increase your assessment, and that's the only way to do it. The only way a condominium or a homeowners association receives funds is if they raise it from the owners there. or if they borrow it and then assess the cost of borrowing it and the debt service on that loan to the owners through their assessments. So there is no easy out for this. If the reserve study mandates that you are not adequately reserving and need to reserve at a specific level, then whatever the proportionate contribution amount from each owner is, their assessment will have to go up that much. And I've seen this with a number of clients already where they've been hit with 15 and 20% increases because they had in past years failed to adequately reserve and they needed to catch up. And Sean described a very, very severe example of that, where the council has to raise over $5 million over a 3-year period. That will be some significant pain for the members of that condominium.
I just wanted to say hello at this point. Wanted to say hello to Theresa. I just saw her her video turned on there for a minute.
Oh, hello. Well, I was just
Teresa.
gonna chime in because I saw a comment pop up about a 5% cap, and that doesn't matter. Basically, they still have to increase to meet the reserve study level.
Right. A unit owner,
Annual amount.
yeah, the unit owners cannot rely on a maximum annual assessment to defeat a reserve requirement. The law makes it mandatory and would relieve the board of that budgeting constraint if, in fact, the reserve study says that the assessments need to be raised beyond your maximum annual assessment cap.
So
Can
not-
you maybe
not
kind of
only does
reiterate that, Michael?
the
Can you
law
kind of
put
reiterate that?
But you make this reserve study.
Yeah, so I think, Gabriella, what you were, or Gisela, I'm sorry, what you were asking is, if there is a limitation on the amount that an association can assess each year, does that limitation prohibit the board from enacting a budget amendment to adequately reserve? And the answer to that question is no. The law requires, and the law would exempt the board from any such limitation in order to meet a legally mandated budgeting requirement.
Thank you. That's what I wanted to make sure that everybody on this call understood. So thank you.
Joanne, are there other questions in the queue?
There is not.
Okay. In terms of just trying to think of certain collection topics that we may not have covered in depth, that one of the things that you might be interested to learn a little bit more about are the different types of bankruptcies. The most common bankruptcy is a Chapter 7 bankruptcy, which is called a complete liquidation. And ordinarily, if a debtor successfully completes that bankruptcy and obtains a discharge, they will not be obligated to pay any debt that was owed at the time they filed. Now, some exceptions to that, well, there are no real exceptions to that, except for liens that may have existed prior to the bankruptcy in that property. Now, a Chapter 13 is called a wage earners plan. And ordinarily what happens there is a person may not be eligible for a Chapter 7, but they nonetheless need the assistance of the bankruptcy court to reorganize their debts. So what they do is they file a petition, they formulate, all of the creditors that are owed money will file what's called a proof of claim in their bankruptcy. And then the bankruptcy attorney will formulate a plan with the bankruptcy trustee and seek the court's approval to implement that plan. Ordinarily, if you're a secured creditor, you're going to receive 100% of what's owed to you over time. It may take 3 to 5 years to get what's owed to you, but you likely will if the debtor successfully completes the Chapter 13 plan. Sometimes Chapter 13 plans work out and sometimes they don't. Sometimes the debtor just finds it too insurmountable and they end up converting that Chapter 13 to a Chapter 7. So basically what will happen is there will be a wage withholding order on that person. That money will go to the trustee and the trustee will divvy it up in the order of priority and based upon who's owed what.
So when you file a lien, can you still accelerate through the end of the year on the lien?
As long as the governing documents permit acceleration, and the acceleration takes place prior to the recordation of the lien, then they can be included in the lien. Because what an acceleration does is it says, this is no longer due over the rest of the year, it's due now. And then at the time you record the lien, it's part of that.
Right. In fact, when we proceed with filing a lawsuit, we'll want to make sure that we've accelerated the account through the end of the fiscal year, if, as Mike said, the governing documents allow for it, because we want to get a maximum amount that we're entitled to in our judgment.
Can you touch on if a board wants to actually, they want to let, how do I put it? They want other people to know who's delinquent. So
Yeah,
can they publish something for that?
I strongly discourage publishing a list of delinquents. One of the reason why I say that is because bankruptcy courts have declared that such publication is an attempt to collect a debt that for anyone in bankruptcy would constitute a violation of the automatic stay and potentially subject the association to sanctions and fines by the court, plus the cost of the debtor's attorney's fees and so forth. And one of the reasons why I caution against it is because you never know who is going to file bankruptcy and when, and you don't always get notice of it. And even if you don't have notice of it, it would still be considered a violation of stay. Now, I will tell you that the liens are public record. The lawsuits and the judgments that we obtain are public record. You know, people can do their own research to find out who's delinquent. But I can tell you that in the past, many years ago, I've been doing this since 1998. In the past, the associations that attempted to do it, it really didn't make a difference. It only created bad blood, so to speak, in the neighborhood because some people were embarrassed and other people were embarrassed for them. And I don't think it has ever truly resulted in much in the way of payment.
Yeah, I would agree with that. Just kind of dovetail off of Mike's comments here. That you know, you got to do I tell my clients, you got to do a cost-benefit analysis and look at what you're going to achieve by publishing the names of delinquent owners. Is it possible? Yes, it's possible. I'd recommend that you have that, you know, give that authority in your governing documents to the board of directors to publish names. But again, there are so many bad things that can happen, as Mike was saying, that could come from publishing names of delinquent owners when there's no benefit, if you will, other than embarrassment. You know, publishing names does not force or compel an owner to pay like a lien action or like a judgment and collection upon that judgment. So there's very benefit and potentially a lot of cost and aggravation that could come out of doing that.
We totally agree, and that's our policy too. Oh, sorry. Maya. I was just going to say we agree, and that's our policy as well. However, we did have a question come up recently that if a homeowner is requesting to inspect the books and records, technically, are we allowed to redact it? We always do, but could they challenge that?
The owners are allowed to know what the delinquencies are. They're not necessarily allowed to know who owes them.
Okay.
Right. So
there's no obligation on the part of the management company to disclose.
If it comes to an account that is in the attorney's office for collections, I would recommend that having the attorney to redact any advice, you know, attorney-client communication, that type of thing that may, you know, be included in whatever is released to homeowners that request that type of document.
Right, and you don't want to share the delinquency reports that the attorneys prepare.
Right. Absolutely.
Even our own internal delinquency reports, I mean, it has names and addresses, so
right.
we usually redact that as well.
So, but I guess what I'm saying is that if any information happens to appear on any documents that are released, that would, I would redact it significantly. So, name, addresses, delinquent balance, and you got to be careful, especially if an account is in the office for the attorney for collections, because of the same concerns that Mike was raising before about potential but inadvertent violation of the Fair Debt Collection Practices Act. If wrong information is produced on a certain date, you could run into some troubles. And there are attorneys there today working against us, so to speak, in this industry. So,
Yeah, there's a whole cadre of what we call trolls out there that are just waiting for us to make a minor misstep and then to try and build a mountain out of a molehill.
Absolutely.
And
Absolutely.
could we have just a small conversation about sharing this information as far as board members?
It's always been my position that any board member, all board members are equal in terms of their directorship and their entitlement to view records. A director has a fiduciary duty to know what's going on in their association. And in order to fulfill that fiduciary duty, they have to have access to the information that would inform them. So a board member may examine pretty much any record of the association. However, that board member also has a duty of loyalty to the association and not to disclose that to people outside of the board. So just because a board member may obtain something from the association doesn't mean it's okay for that board member to disseminate it, because they may be breaching one of their fiduciary duties to the association by doing that. You might jeopardize a contract under negotiation. You might jeopardize a pending litigation matter. You might expose the association to liability for defamation or some other thing. So each board member has to carefully weigh their duties and keep them in the forefront of their mind. But if a board member wants to see something, they can see it.
Right. Just to add, I think those were good comments, Mike, and I agree with them. But I wanted to add that I've had a couple clients who have tried to require their board members, to sign an agreement promising not to release documents and that kind of thing. And I have advised that, well, I really don't see how a board member would be obligated to sign such a document or an agreement or what have you. I just don't think that there's that part of the board member, except for what those types of things that Mike said, which is fiduciary duties, duty of loyalty to the association. So, but I've had a few clients who have tried that kind of thing.
Yeah, I've had a few clients that have tried to make it mandatory for boards to sign things, board members, in order to qualify for the board service, sign certain pledges and things. And I've advised that their fiduciary duties attach from the moment they're elected, whether they acknowledge them in writing or not. And, and there's nothing if there's nothing in your governing documents conditioning this type of oath or pledge as part of your board service, you can't be compelled to sign one.
Right. Absolutely.
So I have a question. What's the consequence of not complying with the new law by increasing fees to fund the reserves adequately?
Sean, you want to go with that?
Yeah, I'd be happy to. In fact, we've given this some thought at the firm and have had some discussions specifically. Now, this was before the latest adoption, the new statute that's going to go into effect that'll affect the whole state. But in terms of when we were just dealing with Prince George's County communities, okay, one of the attorneys at my firm had a conversation with the Maryland Attorney General's office, as well as the COC in Prince George's County at the time, about this very issue of enforcement and who was going to do that enforcement. Of course, my opinion is that any homeowner could potentially bring litigation against the condominium or a homeowners association to compel the community association to comply with the law. But I don't know if you're going to find too many homeowners that are going to want to spend that kind of money in order to raise their assessments, right? So after a lot of back and forth between the Maryland Attorney General's office and at the time Prince George's County COC, the common ownership communities, the Maryland Attorney General's office agreed to take this issue of enforcement on. And now I have yet to see anything as far as enforcement is concerned. I have yet to see any action taken by the Maryland Attorney General's office. But I have seen the Karen Strawn with the Consumer Protection Division out of the Maryland, the AG's office. She has been willing to personally come and to meetings of associations to kind of not pitch the whole idea of reserve studies, but just to kind of explain the law and what types of consequences there would be. Now, I've done a lot of thinking about what kinds of consequences there could be, and it wouldn't just potentially a lawsuit, which I think is really kind of, you know, what the question is about. But I'm concerned, especially when you have life safety issues that are not being addressed, where people could be injured or killed, okay, by this one client that I have, where it's a 14-story building. I mean, if they have falling concrete from 14 floors up, that could really hurt people. And so I'm concerned that if nothing is done and somebody is injured, then there potentially may not be coverage. You know, I'm concerned that, I don't know for sure, but I'm concerned that if the master insurance carrier were to learn that the condominium was not complying with the law as they should, then there could potentially be a loss of coverage.
And you also have to be concerned about receivership as a potential consequence. If the Attorney General's Consumer Protection receives a complaint from an owner, and they can do that for free, and they do it all the time. Yes. A logical consequence could be that if they determine that the board of directors is routinely failing to adequately reserve, that might prompt them. It hasn't happened yet, but it could prompt them to petition a court to appoint a receiver to take over and manage the affairs of the association. And anyone that's been through that will tell you that it is horrible and it's expensive, because the receivers don't work for free and they charge way more than management companies do.
I have another question. When the attorney receives a delinquent assessment file, do you check to see if the homeowner is renting their townhome?
Ordinarily, if we see that the owner's mailing address is an address other than the unit, we assume that there's someone other than the owner living in it. Oftentimes it's of no consequence. Where it would become of consequence is if your lien notice didn't get a response, recording the lien didn't get a response, filing the lawsuit didn't get a response, and you end up with a judgment. Where that may come into play is if you want to determine if garnishing rent is a viable option. Now, I will tell you that oftentimes we're reluctant to do rent garnishments unless we have a copy of the lease, because you can proceed against someone and find out later on that they're the mother or brother or sister or child of the owner of the unit. They don't actually have a lease. And, you know, you can go down that road. But if we have a lease, and many condominium associations have provisions that require an owner to keep a lease on file. If you have the lease, you can easily demonstrate to a court that there is an obligation to make a rent payment. You know what the amount of the rent payment is, and you know the identity of the people who the garnishment is to be served upon. And if they fail to answer that garnishment, then it makes the contempt proceedings that follow a whole lot easier to prosecute. Sean, do you have anything to add to that?
Yeah, we used to try like a leasing addendum that would provide for payments to be made by the tenant directly to the homeowners association in case of a delinquency. But I haven't seen that kind of thing done in quite some time. But I will say this, that some counties, like for instance, Howard County and Prince George's County, have requirements for landlords to obtain a license before they rent their properties. And in order to do that, they've got to, I believe in Howard County, they're required to show proof that they've paid their assessments, that kind of thing. And so I have had some clients ask that we report a delinquent owner to the whatever county licensing department who licenses the rental units. And so we got to be very careful with that. And I would recommend, if that's being done, that it come from our office or the attorney's office, whether it be Mike's office or my office in that case.
Mhm.
Yeah, and making an inquiry as to whether a license exists is something that you could do. Necessarily reporting a delinquency, you got to be careful about running afoul of the Fair Debt Collection Practices Act, because again, there's a whole cadre of attorneys waiting to sue you for something like that. But if you have a system for monitoring that, one of the ways to do it is to check your own system to see if the owner is receiving mail at the unit or some other unit. And for those who have an off-site address listed on your roster of owners, to write to them and say, we notice that you do not live in this unit, or appears you do not live in this unit. If you're renting the unit, you should be aware that you're required to have a rental license and file a copy of the lease with management, so that we know who to contact in case of emergency. We know who we're dealing with if we need to have access to a unit and so forth, and to try and compile your records. Problem with leases is they expire and you get new ones, and sometimes tenants move out, new ones move in, so it can be a challenge and an ongoing process. But if you're going to try and utilize that as a tool for the association, it does require some legwork.
If you have one or more people buying condo units for rental property, how does this affect homeowners or persons looking to buy?
Well,
Sean, go ahead.
I mean, I don't know how many people we're talking about, but that could eventually have an impact on the FHA eligibility for a community association. So if more than 50% of the community is being rented, then that they might not get qualified under for FHA financing. And that is something that is important when we're talking about collections. Being FHA qualified is important because of the low down payment requirements for an FHA loan. It's important to have a lower delinquency rate, and kind of keep a check on the number of units that are being leased in the community, that kind of thing, because those can have an impact on whether or not potential buyers could get FHA financing.
Yep. And if you cannot get FHA financing, what that does is it suppresses the value of the units in your community, because it eliminates a big portion of the potential buyers, because conventional financing requires a 20% down payment. And if people don't have 20% down payment, they're going to pay less for your units. Having FHA and VA eligibility for your community means that there's a larger pool of potential buyers, which makes it easier to market and sell units in your community for the highest and best price.
You have a homeowner that is renting their townhouse and their delinquent account is with the attorney.
Okay. And what is the question?
It didn't actually say, it just says we have a homeowner that is renting their townhouse and their delinquent account is with the attorney. But unless you have a lease, there's nothing that can actually be done as far as garnishing the rent, correct?
Well, unless you have a judgment, in order to get to the point where you may even consider garnishing rent, you have had to go through all of the stages that Sean described early in this presentation, where you establish the lien, they don't respond, you file the suit, serve the summons, have the trial, be awarded the judgment. All of those things have to happen first. And I don't know from the question whether or not all of those things have happened, but it is not uncommon for some people to get in and over their heads on investment properties. And you may also not be aware that sometimes tenants don't pay. And just because they have someone living in the unit, that doesn't necessarily mean the landlord's receiving rent from the unit. During the COVID moratoriums, there was a moratorium on evictions, and a lot of landlords who had multiple units where none of their tenants were paying had severe financial hardship because they couldn't cover the mortgages on those units. So there's always a lot. There are a lot of elements that complete the picture, and you need to keep in mind that things aren't always as they seem. Just because someone's living in there isn't necessarily a guarantee that the landlord's receiving a rent payment. I have filed rent garnishments where the tenant was like, yeah, well, I owe them rent and I'm not paying them either. I'm not paying you, I'm not paying them, go away.
Ms. Sellers?
Yeah.
I don't know if she can hear me. I think she's mute.
Yeah, I can hear you.
Oh, there you
now.
go.
This is an instance where I accidentally found out that there's a renter in a particular townhouse in my area where I live. And she told me that she was renting this particular address. And it dawned on me, because I'm a board member, I'm the treasurer. And it dawned on me that address sounds familiar. So I came in and looked at my documents and I realized that it had been turned over to the attorney. And the thing that's really ironic is this homeowner has not changed his address, his or her address, to where they're living at another location. We're still carrying the address in Avonshire, but I do know that this lady would not be telling me a lie. She said she and her daughter lives there and she's renting. Because we were talking about people putting out trash, or she was saying that she had somebody put trash in her trash can after the trash people had come to pick it up. And I was out there putting trash out or doing the recycle, and she was shaking her head complaining. And I say, are you a homeowner or a renter? That's when she told me that she was a renter. So, you know, these homeowners that are renting, they're getting away with a lot of stuff. You know, they're not listing their address. They're renting the townhouses, particularly in my area where I live. I have a lot of renters in my area, and they are not listing their other address. They're still listing the address here in Avonshire. I'm sorry, I said the community.
One of the things that we do to try and locate people who have an address that may not be valid is we can do a PM search to see if there's a forwarding order. We can also do an MVA search on the owner to determine if their driver's license has another address, as long as they have a driver's license in Maryland. So there are tools that you can use. We also search like LinkedIn, Facebook, those types of things to try and find leads on people. But you know, if push comes to shove, an MVA search is usually turns up a valid address.
But my question is, this is to our management company. Aren't we as homeowners are supposed to, say for instance, I move out my townhouse and I want to rent it out. I file for the renter's license and everything. I'm supposed to give you notice of my change of address, and if I change my telephone number, so it can be on file. So in case you have to get in touch with me, what are the I know there should be a requirement, but how can you enforce it?
We can't,
guess
we
can't.
request it, we request it, but ultimately it's on the owner to provide that information. There's no way we can
Right.
really get that information unless you provide it.
But in the case that you were citing, where you learned of the name of the tenant who is living there, I would report the information that you've learned to management so that they can pass that information along to the attorney's office.
Something else you could do if you happen to talk to her again is ask her where she mails her rent checks, because you're
Yeah.
trying to get a hold of the owner.
That too. Yeah.
Yeah, well, she was a very nice lady. I was just surprised to learn that she was renting, because she was agreeing with me about homeowners not putting out their trash the way they're supposed and not doing the recycle correctly. And I said, well, are you a homeowner? And she said, no, I'm a renter. And she was telling me that her daughter had just graduated from high school, I believe, and I congratulated her. And then I was shocked that she said she was a renter. But I have a feeling that this particular townhouse, that the homeowner did live there for a time, and he moved out and he's moved someplace else, because I distinctly remember seeing 2 parents and 2 boys, I think, living there. And now it's only this lady and her daughter. So maybe he just hasn't gotten around to turning in his correct address. I'm giving him the benefit of the doubt.
There you go.
Yeah.
Okay, so the next question is it okay to discuss a summary of the delinquency report without names at open board meetings?
No, I wouldn't do that.
Generally, what I would recommend is that if you're going to discuss delinquencies, you can acknowledge how much in the aggregate that the association is attempting to recover, and you can let them know that you've engaged attorneys on the association's behalf to enforce those. And you can provide periodic reports that say, well, the attorney this month was able to recover this much money. That sometimes lifts spirits for people who think that there's no consequence to non-payment. And something that I always counsel my boards to do is to make sure that everyone understands that the board members are also members of the community and also pay their assessments and also have the same concerns as every other owner. And if there is, an assessment increase, that it affects them as well, that they're not doing something to everyone else that they're not also doing to themselves. So they're going to generally discuss collections at a meeting. You can, I wouldn't get into specifics as to addresses and names and so forth, but you can say generally our association's attorney is filing lawsuits on our behalf, creating liens. They've recovered this much money year to date, that kind of a thing. And you can share the aggregate total of the delinquencies.
Right.
I have another question. If they're renting out more than one room in the house per the county licensing, then the owner needs to get a rental license?
Let me understand, is the owner living there under this scenario?
This is from Karen. Karen?
What?
There we go. We were talking about your question. So Mike Neall was asking you a question about your.
Well, I was told by the licensing and also by the village center that we live in. If a renter is living in the house and they have more than one person renting, like 3 people renting, they are required to have a license from the county.
And this is a situation where the owner or the landlord is also living in the same home?
Yes.
Okay. Which county was that you were referring to?
Howard County.
Howard, okay, thank you.
Yeah, because in my community, we have a rental resolution that we require homeowners to provide the lease and the license for their home, for their rental properties.
Yep, that's very common.
Right.
Yeah, I mean, we had a property in here where the homeowner had renters and then they were subletting to other people, and there was about 12 people living in the house.
Gosh.
Yeah, it was
And
pretty
Of course,
big.
that puts a burden on your parking and.
Oh, yeah, there was like 7, 8 cars in here, and people were being picked up all hours of the night, let out. I mean, it was really bad. It was really bad.
I'm sorry to hear you're experiencing that.
Well, we got it taken care of. Hopefully it won't continue, although we've seen some other people coming, so we're hoping it's not happening again. But yeah.
Have you filed any kind of a complaint with the department in Howard County, the rental licensing department?
Yeah, they came out and did inspections. Yes.
Oh, good.
Yeah, they got all the people that they got the owner to get all those people to move out. Yes. Yeah, but we had an issue where the tenant was driving their truck right onto the common area and damaged the common area. It was a whole big thing. But
Oh, wow.
I have a question myself. So we have association, the homeowner is in bankruptcy. She doesn't live there. She actually rents both of her units out. But when called the rental license place, they actually said that they would have to have liens or judgments before they could do anything. Is that, I mean, there's nothing they can do at all without having that?
She's got an active bankruptcy?
Yeah.
Yeah, she's got a pre and a post.
Wow.
So is it because of the bankruptcy that they won't do anything?
Yeah, if it's a Chapter 13 bankruptcy, the
It is.
rental income is the property of the bankruptcy estate, and no one can touch that rent but the bankruptcy trustee. You'd need an order from the bankruptcy court after, filing a motion to terminate or modify the automatic stay before you could do anything. And I will tell you that you'll likely not get that order if the person isn't, because any rental income received on the property is supposed to be turned over to the bankruptcy trustee.
What we were trying to figure out is, can't they do something to take the license back or give her a violation fine or something?
No.
If the county, I'm not aware that the county would be willing to do it,
Right.
or to attempt to do it. Are you, Sean?
Well, I don't think they're going to, no.
Right.
Not in a case like that, no. Not without a court order,
Right.
but they may not even request one, so.
Right.
Okay. Does anybody else have any questions?
This has been great.
Yeah.
Thank you.
Awesome.
I think that, I don't know how often you do this type of thing, Joanne and Theresa and Heather, but this is wonderful.
Yeah.
Ms.
I
Sellers?
appreciate your time, both of your time tonight.
Yeah, Ms.
Sure.
Sellers just raised her hand.
Okay.
I noticed in other counties, the county rules or regulations or require that a homeowner that wants to rent out their townhouse or property needs to give a copy of the lease agreement to, I guess, the management company and their license number. Is there such a thing for Montgomery County? Is there such a requirement for Montgomery County?
Not that I'm aware of, but I'm aware of the licensing requirements in Howard County and Prince George's County. Mike?
Yeah, I mean, there may be an inspection requirement, but
Right.
I'm not aware that a copy of the lease is required to be filed with the county. It's just
Right.
whether or not you're eligible, because the county is not a party to the lease agreement. They're a party to determining whether or not it's eligible to be leased.
Right.
Yeah, I know they do have to have inspections in Montgomery County. They have to pass inspection and they do have to apply for a license.
Okay.
But I guess they're not required to give their information to the management company. So that's why the management company don't always know when they're renting out their townhouse and not changing their address.
And even when they are required to give it to the management company, sometimes they don't.
Yeah.
Okay,
Very true.
okay, thank you.
Well, if nobody has anything else, I'd like to thank everybody for attending, and thank you very much, Mike and Sean.
Sure.
Very
Mhm.
informative.
It was my pleasure to help out tonight. And if you ever need anything like this again, I'm glad to pitch in. Sean, it
Great.
was great seeing you.
Here, same here. Happy to.
Always a pleasure to have you both
Yeah.
present. Thank you.
Thank
Very
you,
much.
guys.
Yeah.
All
Thank
right.
you.
Thanks,
Have a
everyone.
wonderful night.
Have a
Thank
good
you.
night.
Night.
Thank you
Right.
all very much. Been very, very helpful.
You're
Wonderful
welcome.
to
Thanks for
hear.
Very
attending.
good. Thanks, George.
Thank you, guys. Have a good night.
Thank you.
Night.
I know.
Good
Good
night.
night.